Okay, so welcome back after the break, and I'll hand the floor over to Janneke, who will give more information on legal issues relating to cloud service level agreements. So, Janneke.
Okay. So earlier we talked about the strategic and pragmatic approach about cloud services and some basics about the standardizations. So I want now to get more a deep dive, and I already realized that we cannot handle, it's just a global overview that cannot handle all the topics, of course, but we can discuss, there are so many topics related to SLAs, so I will give later on some time to discuss some topics more. The agenda will be that I will start with how we came from standardization to practice in relating to our SLA-Ready project. Then we'll deep dive in what are the 4 main categories of service level objectives. How can you make informed decisions after that? And I will get some use cases from the real practice which you have with SLAs, and maybe some other tips and tricks if there are time, and if there are time as well. I heard already that Christian has also some use cases as well, so maybe we can discuss that as well. As a result of our SLA-Ready project, we have set up the common reference model, and the methodology of the project is built on building block thinking, and it makes the combination, of course, between the 1 and 0 thinkers and the pragmatic people who are more exploring like that. So what we did is we started here with analyzing the standardization guidelines and all other ISO-related guidelines. So that are the standards what you have to do. Based on that, we have the common reference model requirements, whereof we have the common reference model of cloud SLOs, and also the market. The SME market has some requirements and standards. You all have questions, or not only the SMEs, but also the governments. Everyone has questions regarding requirements regarding cloud services. So we even get that feeling, and well, it's one of my daily practice as well. I always have the questions about the SMEs, and we find some really use cases. There are people who have no knowledge about it. Some have some basic knowledge about it, and some are really experienced. Based on that, so you come to use cases where people can recognize what kind of situation is here. It's not easy to, it's not easy to, if you have no idea what the standardizations like ISO, they're already basic, but how do you make that in practice? And that's what we have to do here with the SLA-Ready project. And of course I will do that later on, some use cases. That's how we bring standards to practice. So, as I said this morning, SLAs are an important part of the ecosystem, but it's not the only, it's just a particular part, but it's very important. Well, as cloud services have the ability to connect to each other, there is definitely no one SLA, but there are more SLAs. That makes that is I like it because, it's connected to each other. It's connected, it's hyper-connected. We've got all kinds of services. And if you see like this one, there's a whole value chain, and it's even getting more spectacular, like so I say, yeah, it's more spectacular when we are going to the Internet of Things, of course. Then we've got more and more connections. So you see, the infrastructure, your basic cloud provider provides an SLA. Your platform, if that's over there, but or the software applications builds SLAs, and you can build an SLA on each services. You can make it as funny or difficult as you want, of course. But there's a whole value chain, and it's also sometimes Pandora's box, but you can also see as some real added value if you understand how to build them. On the other hand, you see that the value chain is that there is if you have the supplier of the cloud service provider, you provide to the infrastructure provider or the platform provider, to the application provider, and then to the cloud customer. So that's a normal chain, but please remember that the cloud customer could also be a cloud service provider and also be using an SLA. So you don't think that you are on the end. If you are a provider, or if you are buying cloud services, there would also be an SLA on which kind of topic. And even if you're a cloud service, look to a simple data center. They provide some infrastructure. Their customer is the software as a service, the application layer. They have their own customer and they sell it to their customers, but they also have end users and customers. They also have an SLA. So there is no particular SLA. It's a whole chain. So when we are zooming into SLAs from a legal and contractual management perspective, we are based on international standards and best practice. You can assess 4 main categories of service level objectives. Well, as we said, we analyzed all kinds of standards, and these are the 4 main topics which should definitely be covered and addressed in an SLA. It's the performance, of course, this everything about availability, uptimes, measurements like how will you handle with the performance. The securities, like the incidents, how are you monitoring and how are you encrypting? Who is authorized to use the service? Bless you. And who is authorized to access to the services is also a security part. And as cybersecurity is one of the topics and pillars over here, and for the next decade, so it should be definitely addressed. Of course, you have data management. So what type of data? Who is allowed to see which data? Are there backups? Where is the data standing? The people want to be in control of their data and how it will be managed. And of course, last but not least, is personal data protection. Those are all kinds of topics related to the new GDPR. So what type of personal data? How do you store them? Do you delete them at the end of the services? These are the main topics that definitely should be addressed. There is, of course, built SLA lifecycle and a data lifecycle. Yes, and I think I will go deeper in that later on. You have to remember that the current maturity level of SLAs, which we analyzed and regarding the standards, is very low. And you probably all have the experience as well, but it's less than 50% covers the objectives, those objectives in the SLAs based on the standards. So we have a long, long road to go, but if everyone address those topics, we can build good SLAs. Well, as a tool, of course, you can use international standardizations. This is one of the cybersecurity. You see here some topics which you have to address on the topic of cybersecurity to be addressed. And you, of course, you need to monitor every time, especially when it's on security. Because, well, it's an SLA is even an ongoing document. Even cloud services are an ongoing services. So monitoring is key in this topic. So I will now dive into the personal data lifecycle. It's still 519 days on approximately to go before the GDPR is in force. So we have time to do. Well, if you would see that personal data lifecycle, you should be address all the kinds of topics to be to get the maturity level on a high level. It's always like you can see, it's personal. It's about personal data. So that it's personal identified or identifiable information related to an individual. That's personal information. There's always an actor, there's always a trigger, what makes it personal data, and there should always be a legal basic and a purpose to collect or to obtain personal data. It's always back in the law again. So we start with how to obtain the data and what kind of data do you collect. What type of data? That's the point where you're starting. Analyze that. After the next phase is some applications create or derive data on itself. Like data is also traveling. Especially in cloud services, there is a lot of applications derived data will be over there. So that's the other part and one of the important questions. Those two parts are most of the time most important things where data will be created or specialized when they are in the cloud services. The next phase is, of course, how do you use the personal data with your application, and on what legal grounds are they based? In the law there are 7 legal grounds. One of the there is one. The most two is if you need to have a consent of the person of the data subject, or there should be the legal ground is that you have to collect your data from a contractual perspective, because you need to provide your services, because you arrange that contractually. That are the most regular legal grounds for using personal data. Storage. How long do you store your personal data? That's one of the requirements of GDPR as well. Basically, if you store personal data, you have the incentive based on the legal grounds. You're only allowed as long as it's necessary for the legal grounds. So if you provide a service for a couple of years or provide some healthcare service, it's only for that small part, not for the whole entire life chain. It's just for one part, and I know a lot of cloud services are store their data for as long as they use the services, or it's just all in the services. So if there is no longer a legal ground, based on the laws, you're not allowed to store the personal data anymore. The next phase is archiving. Is a little bit, same as storage, but then you can archive personal data on different ways. You can do a depersonalize is one of the objectives. You can encrypt it or anonymize. That's one of the biggest requirements. So it's not, if you anonymize, it's not really findable which kind of person is behind the data. The last phase is to destroy and delete PIA when there is no legal ground anymore. Deletion is, of course, when the service is terminated or something like that, you have to delete the personal data in the systems. But I know, probably you also know, sometimes it's technically not possible to delete and destroy the personal data at all. And if you build cloud services, you should be aware of that there should be at the end of termination of the service, when you're still stored personal data, you have to delete it. Of course, unless there are also some other legal exceptions, like I know in the Netherlands is the tax reasons, you have to store it for 7 years. Probably also here, I'm not sure, but probably think it's everywhere the same. So that is also legal ground to store your data for longer than the necessary providing your services. And this last one is one of the things. Yeah, I also have discussions with the technology people. From the legal perspective, it's clear. If you're not using the service, you have to delete the personal data, because you have no grounds to store or to obtain it anymore. But from a technical perspective, it's not always possible. So, please remind that it should be by design included in the services. So basically, I said there should be no PI by default. And it's to avoid personal data collection. So you have it's not any risk anymore. However, of course, there are also exceptions. I think it's based on data minimization. If you have that in your background, because every cloud services, if you want it or not, they are collecting data or personal data. So there should be no PI by default. That should be if you are technology and developing applications or services. It should be by default. However, if you are doing that, do it as if by design. Remember that if you engineer your system, that they always should be process personal data. The last one is de-identification by default. De-identify or delete personal data as soon as there is no valid legal ground anymore. So these are three things you have to in your background when you're developing cloud service or applications. Then you're definitely sure that it will be easier to follow the rules about the laws. Just tip one, already tip one, some of the one of the, if you also collect personal data. So it's data minimization, data isolation. So you have to isolate personal data. It's like if you use private cloud or open cloud, there's also a kind of difference. Well, data retention and data deletion. Remember, there are different laws and different requirements. Like I said, the tax requires for data retention for 7 years. Other grounds are earlier HR data. Regarding your employment agreement is well, as long as you're employed by your employer. So you have to zoom in and address all phases of the personal data lifecycle. Then you're sure everything is connected. And I think data encryption by default is also want to make sure it's a combination encryption with the data and the security as well. Encryption. If I see in the Netherlands we have the Data Breach Notification Act. So you have to notify when there is a security breach. And you have to notify the data subjects only when it's not encrypted or when it's a high risk. So if you encrypt your data, the risk is lower that personal data could be leaked and that there should be a data breach, because that's only related to personal data. So encryption by default, and be accountable. You're responsible. And I think even with GDPR, it's the responsibility is getting more. Even it's not only to the data controller, but also the data processor and below. So yeah, even as cloud services providers, you get more responsibility to control the data. So I think it's a good one of the things to be prepared for the GDPR in the next few days or days. Yeah, it's only 590 days. Are there any questions? Yeah.
According to the data minimization, take into account that for most of the applications that we use, we don't pay anything, so they're free. And basically, if you don't pay for the app, you are the app, or if you don't pay for the product, you are the product. How is that basically overlapping with data minimization?
Well, that's a problem with free products. You all know that. You pay with your data. It's like the Facebooks and the Googles. And that's one of the reasons why the GDPR is coming, of course, in the next year. There is no real solution. I cannot give a concrete answer to that, because, yeah, they are open, they are free, so the business model is based on data driven. And that should be changed. And I think with GDPR, because these are also principles will come back in a GDPR, which is basically written for the big Googles and the Facebooks. However, yeah, you as a SME has to be also have to be compliant with the GDPR. So that will be the biggest challenge, and that's where there's a big leak between the writers of the GDPR. They are only thinking about the big ones and not on the SMEs. So we have a challenge.
Thank you.
Okay. Yeah.
Hello. So you said regarding data retention that you may need to keep the data for multiple years legally. So I don't know, for example, if a client leaves my business, I have to keep his data?
If your client leaves your business, so that means that the legal ground is the contract, because you're allowed to collect the personal data because you have a contract with your client. It's business to business. Yeah. Basically, you should delete after the termination period. However, and I will handle this later on with some use case, of course, of the SLAs. It could also be a risk. You have to migrate the data to your client has to migrate your data to another provider or something like that. So you have to work on that as well. So it depends a little bit about the services. There should be also a period for data migration in a SLA, of course. And but basically, if you see to the laws, it should be to delete after termination.
In which instances do I need to keep the data regardless of the contract?
In which sense?
Instances. In which cases do I need to keep data, even if a client terminates?
Okay, do I understand your question correct? That you want to address.
Are there exceptions where you should keep data of certain clients, even if the contract has been terminated?
Yes, like I said, other laws could be an exception. Tax is one of the things.
Yeah, but the provider is not responsible for keeping the data. I, as the company, am responsible for keeping the data. So, as a service, I should be able to do a backup of the data and store it somewhere. But here's the difference: the law says that if company A, the law says that the company should keep financial data for 7 years. Independent of what software I used, if it's cloud, if it's on-premise, if it's Excel or anything. So I think this is the question that you're addressing. Mm-hmm. I'm buying a service from that company B. Mm-hmm. Does that company B have to store the data after I terminate the contract, or is my responsibility as a company owner representative to store that data?
It's basically your customers, but they should be allowed, or there should be a possibility that they can get their data. If they terminate the services, they should get back their data. That's what should be addressed also in the SLA. Of course, it's their responsibility to keep that data for other reasons. But you have also to realize that probably if you don't have any backup or that you don't give the data back, they have still their data. They still need their data. So that's the difference. And I think you have to address that in an SLA. What's going to happen after termination with the data? And basically you should provide the data to your customer back. And then it's their responsibility. So, and then you have to delete it from out of your systems. But still, you have also your own responsibility to comply on tax regulations as well. So,
if you're talking here about personal data, and you do not collect them, you get the data from the client, then you must have a data agreement. So you should have the stipulating the respective conditions from the data agreement, because you need to transfer them, and you have there all the terms. What happens with the data you receive from the client? What happens in case of termination? So that is stipulated in the contract. The obligations that might come from fiscal regulations usually are related to the obligations of each company, and it's not about the personal data which is transferred. So normally you shouldn't have this kind of exceptions.
Still, well, basically you're not the controller of the data.
Just get the data for processing it because you're offering a service.
Yes, but you're still the processor in legal terms. So you're not, so it's their responsibility, of course. But with now GDPR, the responsibility are a little bit changing. It's got to another level as well. And I think you're not, definitely not, but you store the data as well. If you're the processor or you're the cloud service provider, you store data. There's data to your system. So you're not collecting them by yourself, but you still have a little responsibility.
For sure you have responsibility, but you have all this stipulated in the contract. And what happens at the end of the contract with the respective data which you were storing as part of your service is going to be regulated in the respective agreement. And even if the new change of legislation is going to apply from 2018, the contracts are going to be updated in order to be compliant with the respective law. So I think that these kind of exceptions which the law might overrule the contractual obligations regarding transfer of data and processing and
I think you have to be sure that you're during the contract, there is still a responsibility for as you are a data processor. But of course,
responsibility for sure it exists, and as far as I've found, usually you cannot even limit the liability for these kind of situations. They're pretty rare. Of course, you strive to limit the liability, but especially with clients when they put their personal data in your hands or extremely high confidential information, these kinds of limitation of liability or responsibility is really, really rare. So I'm not referring to the fact that you are not going to be responsible, just which are your obligations in case of termination of agreement and of storing the data beyond the contractual stipulated period.
Yeah, well, it's a last question. We still not definitely, of course, know how far it will go. But still, from my point of view, if you are a data processor, nowadays you have your own responsibility to be secure about all the security measures. So that's your responsibility because you're in control about that from your own system. It will be a more co-responsibility. But even you have the agreements, and still, the law could not overrule, of course, an agreement. So you only can store the as long as you have an agreement with your customer. So that's also topics. Yeah, you have to cover and you have to discuss it with your clients, of course. Because mainly they are the main responsible for the data. So is that okay? Yeah. Okay. Still more on the data protection one. It's still a nice topic to discuss all the time.
What's your take or what's your experience on the challenges that are specific to working with public authorities? So cloud storage for public authorities, because there is a lot of rigidity from their part, because they have to follow some rules, public procurement, that kind of stuff. And also it meets some rigidity from the part of service providers. You said that there is a lot of pre-established rules existing over there. So is that entirely specific, or are these ideas also applicable there?
Yeah, I think it's a global, the cloud service or global approach, but we still have local regulations and local laws. And even for that kind of high regulated, like governments and financial institutes, they also have their sectoral regulations. It's a challenge, but you have to address all of them, of course. And I know from the Netherlands, the government, but also the financial authorities, they are more open to a cloud approach. They want to discuss it, and they will see, okay, we understand you cannot address everything, and even that is about, well, if you see to security reasons, it should be the state of the art. So if you know what's happening nowadays, that's what you can address at this moment. Is that all of it? Otherwise, we can talk about later on.
Are big providers of cloud storage services interested in working with public authorities? In your opinion? Or only small ones because they are more adaptable to circumstances?
No, I think it's both, but I think the background is different because a government organization is a little bit complex. They have a lot of departments as well, and it's not a lean company. And you see that it's the same by a bank. It's not lean. So that's also one of the reasons that they are not adapt cloud services. Like I said before, earlier today, it's about the adoption of cloud services, and that's one knowledge, and one is the lean of the organization, to be lean. And SMEs are most of the time, they are much more leaner so they are more open to adopt it, and it's easier for them to innovate and to get further. So that's a big difference. So now I want to move to how you can make informed decisions about the SLAs. Because, well, it's not always easy to get the whole entire life cycle complete, especially when you are buying or providing cloud services and the SLAs. I think it's a whole life cycle again. Everything is about, well, you start with assessing what are your requirements and what are the main gaps with like standards. What are the gaps with regulations? What are you providing? You have to assess. Preparation is everything. If you write an SLA or if you would read an SLA, if you know that, you can select what kind of cloud service you want to purchase, or what kinds of requirements you want. Really have to get them. It's about selection. If you know what you want, you can focus you on your even on negotiation. You can focus you on the need to haves. Like I said, we did a bit more for a government organization. We're starting with the assessment. We make the gaps between what do you want as a company and what are the basic on the standards. So we have that gaps. Thereafter, we are going to select. So what is really want you to need what a cloud service would be, and what should be in the SLA? What are the important things you want to address? So I think it's also, if you are a provider as well, you have to select some of the need to haves, and I think you should be transparent of what that is. Then you can negotiate and set it in a contract. Because that gives you some guarantees about the performance, about all the backgrounds you want to have. On SLAs, it's also important to monitor them. It's a working document. You have to always monitor them. It can change a lot. And that's also why we get in the last phase updates and terminates. SLA should be updated one time, so because cloud services are also updated. And of course you have to address, like the main question of today, what's happening after termination. This whole life cycle, yes, you have to use them every time. It's not only, I think it's even by all kinds of contracts is useful to get through this kind of life cycles. Otherwise you've got, well, a disconnection. Furthermore, it's good it's building block thinking again. If you have the one, you can go to the further one. So in these types you can bring a more transparent SLA, and transparent SLA is also, you can use it as a unique selling point of your company. You can take it as a potential upsell. If you have got a good basic SLA, that's good. If someone have to be more services or more access support, you can set them to another level of SLA. So you can play a little bit with that. And I think that should be a unique selling point if you have a good SLA, or if you assess them good, or like that. I don't know if you have time. I will go to some. Well, yeah, you can find them like in every kind of contracts. I will go to the in matter of time to some use cases. Like you see, there is access to the usability of cloud SLAs. In the life cycle, this is part of the assessment. Because, well, most of the time it's not easy to find an SLA. If it's a SME provided by the SME or by the largest one, even the big companies, you also have to ask, okay, what's your SLA? They are not public available most of the time. So yeah, and it's difficult to find, read, assess. Sometimes the definitions, for example, Amazon has another definition of availability than Microsoft use of availability. So we need that's one of the use cases where to address how to have access to the SLAs. It should be reasonable. It should be acceptable. It should be, I think, available on a public website so you can compare with them. Well, this on the basics. Some other topics covered in use in the SLAs are the carve-outs. It's a real legal topic. It's always, you have also check SLAs from at the preparation phase, especially if a client like on incident management, the carve-out was force majeure. So it was it's not only the act of God, but they've written down the force majeure so broad that everything was on a force majeure, even if the provider was not delivering the service or was out of services. So on the end, they could not have any credits because it was based on a carve-out. And I think, carve-outs are from a legal perspective are very, very important to review. It could be a real consequence if it's a broad, for example, force majeure, and you're not able to get some credits like that. So this is one other thing. Already have some data lifecycle management. We all discussed it during our discussion about data protection. This one on the part of the life cycle is about updates and amendments. If you have make clear arrangements on the classification on types of data, then you have to even realize that in every data lifecycle you have to review them. And even on data retention, of course, we discussed it as well. There are different types of retention periods in different kinds of laws. This is also one of the main topics. It's not always clear and addressed in the SLAs. It's about all things about monitoring, about what's in there, what's happening over there. So this is one example you see during the performance of your services. And of course we have data portability. I think that is one of the most important, you see a lot of use cases, and especially when you provide it's a large CSP. At the end of terminations, and what are the consequences thereof, you will see most time a vendor lock-in in all kind of SLAs, especially when you go to the big ones. Vendor lock-in is most of the time addressed in it, and it shouldn't be, because it should be it's a high risk if you have your or you want to terminate your services, and you're working as SME across Europe. At termination, it's a vendor lock-in, so you cannot extract or export your data, for example, your data anymore. Or you want to migrate it to another data provider or another service provider. It's always a discussion. So you have to address it should not be a vendor lock-in, but you should address those kind of topics to have, like we discussed before, like you said, the vendor lock-in should not be part of it. Like data portability, how you can transfer after termination, is most of the time not addressed in SLAs. And that's also one of the main questions we have in daily practice, of course. What's happened after that? And you have to address it. We see it like here in the use cases, it's not addressed, and you've got a real problem if you want to terminate your services. Another part of termination is also of termination clauses in SLAs. It's about the impact of the services. If it's a high impact, if you have a customer who is on a daily basis use cloud services, at the end of termination, you cannot terminate it immediately if they said, okay, we will stop the services. Because, well, then the service went down, you don't have any access anymore. That's everything you want to avoid. Because most of the time they use cloud services for all the whole businesses. So it's high risk to get the services down immediately after termination. There should be a grace period, and it should also be addressed in the SLA. Most of the time it's high critical operation. It's used for daily business. So termination and what's happening thereafter, I don't see a lot of and that's why we also have the questions over here. It's most of the time not addressed in the SLA, and it's just a real use case, and well, it's up to your writing on the SLAs to get them clear and transparent in your SLA. I'm looking. Do we have time or not? Sorry. Well, I heard there are also use cases from the from the public, from the audience over here. Maybe they want to share some use cases, or we can, I don't. Should I be? Are there any people who want to share some use case, some real life, if they have some problems with the SLA when they assess them, or when they are reading them, or we can leave them for later on? Okay, that's okay. So I will end it. We basically work in a 4-step methodology. We can use it on every kind, not only for cloud services, but in all kind of digital transformation. So keep it as is when there is no alternative available yet. So it's as is, like the law says, it should be state-of-the-art security. Well, what's state-of-the-art? And you know, technology guys, you definitely want to know what it is. But it's just what nowadays is available about security. Start from a blank sheet of paper, if it's possible, of course. Migrate and transform and clean up systems and process. And one of my important things is the data lifecycle. As data is everywhere and always, I think we got a digital economy, but also a data-driven economy. So you should address them in all the steps. And when I start with assessing like SLAs or even with contracts, we start on a blank sheet, write it down, go it on. And last but not least, you have to repeat it every time. Every time you have to get to the whole cycle. When you are developing any IT services, it's all about security, identity access, data protection, data right management. In all the cycles, get through, and it's not one time, but it's every period you have to update that. And also my design, I love the principle to address it by design. So this is basically, we addressed already questions, so I will think we go to the next part of our workshop. Shall I give it to you, Nick?